Does a will overrule a trust? Hello, I'm attorney Thomas Burton, and that's today's question. So sometimes this topic comes up with the idea of a will, that the will would cancel out everything else. In my experience, that's just not true. If you've seen some of my other videos, you're going to need to look at what governs the asset in question. Is it a probate asset or a non-probate asset? And in most cases, if there's a trust and a will, the trust will overrule the will if assets have been placed inside of the trust during life. Because remember, the will only takes effect upon death. If the settlor, the person who created the trust, set up the trust during life, transferred, let's say, their home into the trust by deed during their life, then the terms of the trust govern that piece of real estate, that home. The will doesn't matter because it no longer governs that asset. We took that asset out of probate and put it into non-probate using the trust. If you work with my office and we set up a trust plan, we usually do a pour-over will in conjunction with the trust, and all the pour-over will does is it says, if I forgot to include something in my trust, I pour it over, here we go, into my trust upon death. That's why we get that term pour-over will. It's a valid last will and testament like anything else. It's just that the function is to pour it over and use the provisions of the trust to govern the disposition of the estate. So inside the trust, then we can have all the private information about who gets what, and that isn't even in the will. So even though the will may get filed after your death, the goal is there's nothing to administer under the will. It's just there as a backup plan just in case you need it. And the classic example would be, let's say a long-lost relative died a month before you and left you some inheritance you didn't even know about, like a partial interest in a cabin up north, and then you were on your deathbed and died before you got that cabin put into your trust. Well, your pour-over will would say, pour it over into my trust and administer it according to the terms of my trust, which, for example, let's say it says evenly between my 3 children or something like that. So that's the purpose of the pour-over will. But when there's discrepancies between the two, which I don't recommend. So if you set up a trust, I don't recommend keeping an old will around because that can just cause confusion. I would do the new trust and the pour-over will in conjunction. At my office, we usually do them on the same day so that the old will doesn't say, I don't know, let's say the old will said the house went to 1 child and then the new trust says it splits among the 3 children. You don't want to keep that old will around and have one child thinking, oh, the old will says I get the house and that governs, when in fact you place the house into your revocable trust and the new trust says 3 ways among the children. So talk with your attorney about this when you meet with them, but often it makes sense to revoke any previous wills at the time you create a trust and just execute that pour-over will alongside the trust. That again basically says anything I forgot I place inside the trust, and I want my estate to be governed according to the terms of the trust as signed by me on this date as amended. And that allows you to amend the trust later if you want to easily make a trust amendment and add or delete someone to the trust or add a charitable bequest or something like that. You can do that all inside the trust and you don't need to execute a new will at that point. So that's an excellent question, one I see come up sometimes, so thank you for asking. Thank you for tuning in. And if this video has been helpful to you, please consider giving it a like so that others can see and benefit from this information as well. Thanks for watching, and we'll see you next time.